Mr. Bewley.
My Lords, over lunch, the point was made to me by Mr. Ruck-Keene, who acts for the intervener, though he's not speaking, and it seemed to me a point I could legitimately relay on. Not necessarily that there is any misapprehension about this, but just to make sure that there isn't. That in relation to the use of the respective use of Section 2 as opposed to Section 3 of the Act, the 83 Act, it is absolutely not the case that you simply use Section 2 where you're contemplating a short admission and Section 3 where you're contemplating a longer admission, because there are different criteria. One is about admission, one's about treatment. If you think treatment is needed, you use Section 3. And that also has a knock-on consequence, I think, that it's absolutely not right to think that a Section 3 admission will necessarily be long or even beyond 28 days. There's no rule to that effect. My learned friend came, I think, quite close to giving evidence about that, but there's no basis to assume that one way or another. That point aside, I said that I wanted to deal, and I'm going to try and do it very quickly because I'm conscious of time, with one last point on the appeal. It relates to ground 2. So this is detention, redetention ends, Section 117. And ground 2, as I understand it, really has two supports. One is the point which we've debated fairly extensively, which I don't propose to go back to, which is this idea that ultimately you can't provide Section 117 support to a person in detention. If that's right, what's the point of making a decision? But the other limb, and the limb which, as I understand it on their case, provides, if you like, the linguistic basis for the argument, i.e. how do you get it out of the wording of Section 117, is the argument based on Section 117.1 of the Act. And the argument, again, as I understand it, goes like this, that the preconditions, be they 2 or 3 of them, in Section 117.1, for a person to be entitled to aftercare services, are not merely, as we would submit, one-off conditions, but they're ongoing conditions. In other words, if you cease to satisfy them at any given point, you cease to be entitled to Section 117 support. Now, this brings in the proves too much point, which is the point I just want to make, and I hope make good. If on this analysis, then, frankly, never mind whether it's 2, including a composite, or 3 conditions, 3 things have to be satisfied at all times for you to be entitled. You have to be detained or have been detained, I think my learned friend would accept. You have to cease to have been detained, and you have to have left hospital. And therefore goes the argument, if any one of those things, I think the argument has to go like this, if any one of those things ceases to be satisfied, then you cease to be entitled to the services. Now that does, in my submission, directly force one to conduct the proves too much point. Because one of the conditions, it's true, is ceasing to be detained. And let us assume, it may very well be right, that means being detained under Section 2 as opposed to Section 3. Let's just assume that.
What? I'm sorry, it can't be right.
Section 3 is, did I say, I meant to say Section 3 is opposed to Section 2. I'm sorry. Sorry. Let's assume he's right about that. He may very well be right about that. The other one is that you have to have left hospital. So if you take seriously the argument, which is you have to satisfy all of the preconditions, then it doesn't matter that you're not re-detained under Section 3 if you re-enter hospital. Presumably re-entering hospital doesn't mean crossing the grounds or even going in for a day appointment, but it would include, certainly, as happened with JG in this case, being admitted to hospital. For example, being admitted voluntarily for treatment, perhaps.
It could just be left hospital after ceasing to be detained under Section 3 or equivalent. You read them together.
Well, you can't because one can see, and as I said on the facts of this case, they are separate requirements. So
they're a sequence, aren't they?
They're a sequence. I mean, the leaving hospital, sorry, put it the other way, the ceasing to be detained and the leaving hospital will in some cases happen at the same time.
As it says, yes.
Yes, they can happen at the same time. Yeah, sorry, it does expressly say that.
Yes.
But as it also says,
yes,
they may not.
Yes.
They may not.
So you cease to be detained, you're then in, as JG was, in
yes,
hospital for
correct.
A period thereafter, and then you leave, and that's the condition satisfied.
That's the condition satisfied. But the argument that's put against me is, well, that
Condition can be unsatisfied again. That's
exactly.
the argument against.
The argument against me is, well, they can be unsatisfied again, and that's how, by operation of law, you cease to be entitled.
It's a bit overcomplicated to say that you cease to be detained anyway, and then that means that the section no longer applies.
Possibly. I'm not sure. I'm sorry. I'm just going to be honest and say I don't think.
So that was intended to be a helpful point to you.
Yes,
I think the argument against you is that the section no longer applies because you cease to
Yes,
be
exactly.
detained, and
that's
that
my
seems
one-off.
a bit over elaborate to me.
Yes, exactly. Well, that's my one-off point. That's my one-off. In other words, they are one-off. They plainly are one-off conditions. I think that's another way of putting that point. I respectfully agree with my lord, and I'm grateful for the assistance. Sorry to have been cautious about whether it was assistance.
You never want to accept agree to an answer.
Well, I'm never. Well, until one is sure what
Yes.
that's a danger, as I'm sure your lordship recalls. So they must be one-off conditions. You don't. That's that point. Yeah. But in addition, even if you don't get redetained, you will, on their analysis, you will cease to have left. If you've ceased to have left hospital, that would be enough to take you out, and that must mean voluntary admission, Section 2 detention would take you out, as well as Section 3 detention. And that's the proves too much point. I don't want to labour it, but I suggest there isn't actually a logical answer. What it does mean, if correct, is that they don't have a linguistic route to ground 2. In other words, they don't have a provision in the section. They can say, well, here's the thing that brings the thing, here's the wording which brings the Section 117 support to an end by operation of law. There's nothing they can point to. They just have to
they can put it in terms of in subsection 2, if it's impossible for the person to be needing such services, then you don't have to have a decision. That's implicit in subsection 2, really.
Yeah, well, that's the purpose point. I follow that.
Yeah.
And as I said, I didn't want to revisit that. We've had the debate about it. But that's a slightly, it's on any view, a less direct way of getting there. They're not saying there's not a mechanics in the section.
No.
Yes, you put it like that. That's all I want to say about it, because I'm conscious of time and the need to develop the cross appeal. So I come to the cross appeal. Forgive me, I just turn to the room. Next. So, my lord, the issue under the cross appeal is whether, at the point of redetention on the second occasion, in the fact of this case, JG was ordinarily resident for the purposes of Section 1173A. Oh, sorry, I said whether. I should have said where she was ordinarily resident, in circumstances where she was actually living in Swindon, no dispute about that, but she was doing so pursuant to a placement by WBC, pursuant to its statutory duty. You know the answer we give to that. She was living in Worcestershire. And we say that outcome is dictated by the logic of the judgment in Cornwall. So I break my submissions under this head down under actually 2 points. First of all, what is the ratio of Cornwall? That's a question which people have puzzled over. Well, I see my lord smile. I mean, it's not a judgment which has yields all its secrets in one reading, if I can put it like that generally, but there we are. It must have a ratio. It did decide something, and it's important, frankly, for this court to resolve any doubts about it. And as a subset of that issue, a critical issue, but I won't say it's a so what is the role in the reasoning of the deeming provisions in the legislation the court was considering there? That's the first point. The second issue is, if you accept our view of the ratio, does that ratio, or does the underlying logic which led to that ratio apply to ordinary residents under the Mental Health Act and to the circumstances we're dealing with? Those are the 2 issues. So I deal with ratio first. In order to deal with this point, there are 2 cases I want to go through. One is obviously Cornwall. But before we go to Cornwall, I just want to take you to Shah briefly. Shah is obviously the often regarded as the locus classicus on ordinary residents. I should have said it starts at 425. There's a very well-known passage, which I don't propose to go back to because I'm going to take it as read unless the court tells me otherwise, where Lord Scarman sets out the basic effect of ordinary residence. So, I mean, at the risk of oversimplification, in most cases, it's where you live with a settled purpose, etc. You know that. It's set out in all the written cases, all of the lower courts. I don't go back to it. There's another aspect of Shah which is picked up by Lord Carnwath in Cornwall. And so I just wanted to tease that out because it plays a part in understanding what's going on in Cornwall itself. So as to that, my lords, sorry, it's page 453 of the bundle to start. It's the start of the judgment of Lord Carnwath. Lord Scarman, I should say. And he explains the provisions there at the bottom, towards the bottom of page 453 that are actually in play in that case. So it was Section 1 of the Education Act 1962. And if you start to read into the passage from Section 1, you'll see there's a reference to providing wards on persons who are ordinarily resident in the area of the authority. So one might think, well, actually what it's about is ordinary residence in the area of one authority rather than another. In fact, that's not the case. And you can see that if you go, first of all, over one page to 454, because you may have picked up the reference to regulations. So this is all subject to regulations. We pick it up at letter H. Such regulations were, amongst other matters, to prescribe the conditions and exceptions subject to which the duty was to have effect. Regulations have been made from time to time, and they have always included an exception based on a requirement of 3 years ordinary residence in the United Kingdom. So leaving aside ordinary residence in the area of an authority, there's an eligibility requirement of ordinary residence in the United Kingdom. And then if you go to 455, and again it's at the bottom of the page, we can pick it up. Lords, can I ask the court to read from 455 letter H to the end of that paragraph, first of all? And then picking it up, he says this. The first question, the entitlement question...
Sorry, where are you?
I'm so sorry. So I was asking the court to read from the bottom of page 455
Yes.
over the page just to the end of the paragraph, so where it says section 7.
Thank you.
And then I pick it up. The first question, the entitlement question, being one of statutory interpretation, is legal in character. It is related to an applicant's right. The second is, and this is a phrase that surfaces in Lord Carnwath's judgment, the second is administrative and fiscal, and significantly is ultimately for decision by the Secretary of State, which we also have in our case. And then I just, for reasons of time, skip over, but if I can again pick it up at letter C, the problems, allocation and entitlement, the problems are wholly distinct. One is justiciable, the other is not. Well, never mind that, we'll see Lord Carnwath deals with that. But this is the important bit. If, as to which I offer no firm opinion, ordinary residence in an area of the local education authority has a special meaning when the distribution of the fiscal burden between local education authorities has been considered as a matter for the exercise of the executive discretion of the Secretary of State, it does not follow that such special meaning is to be attributed to the term ordinary residence. And the point that's being made by Lord Scarman, and certainly this is what Lord Carnwath later makes of it, is therefore that in the context of ordinary residence being used for those administrative and fiscal purposes, i.e. allocation of responsibility, it may indeed have a special meaning. The statutory context may dictate a different result from the one that the House of Lords in this case fixes upon. So that's all I want to say about Shah, and then we've got the well-known passage which I don't propose to go back to. Then picking up Cornwall, it's in the next bundle for I don't think anyone will be using it. It's tab 44 again, sorry if that's irrelevant, but it starts at page 737 of the electronic bundle. Just on the facts briefly, I won't take it from the head now, I'll just tell you in as efficient a way as I can. So it concerns the ordinary residence of a service user P. P originally lives in Wiltshire, and whilst living in Wiltshire, he comes to be provided with services including accommodation by Wiltshire under the Children Act 1989. His parents then move, I think either just before or just after, it doesn't matter, to Cornwall, and he is placed by Wiltshire in South Gloucestershire. There are deeming provisions in the Children Act, I'll come back to say something more about those in due course, but just note it for now, which have the effect that for the purposes of the Children Act, and only for the purposes of the Children Act, his ordinary residence in Wiltshire is preserved as to so that Wiltshire's responsibility is not shifted by having placed him elsewhere. But those deeming provisions don't apply, at least on their face, to any other legislation, including the National Assistance Act. He turns 18, the question arises, he becomes entitled to services under the National Assistance Act, so the question which arises is, where is he ordinarily resident for the purposes of the National Assistance Act, in circumstances where, well, his parents are in Cornwall. At one point that's important, but for the bit we're worried about, we don't need to worry about that. His placing authority is Wiltshire, and he's living in South Gloucestershire. I've never understood why another local authority intervened, but I don't want to get into trouble about that. So that's, as it were, the conundrum. With that in mind, I'll just come to the key passages first of all, and then I want to pull back and say something else about the way the deeming provisions work. So first of all, paragraph 43, where Lord Carnwath first of all picks up on the Shire point that I referred you to. 765 of the electronic bundle. And it's paragraph 43, and in due course, perhaps I'd ask the court to read that paragraph as a whole, but for reasons of time, can I simply say what it does is that it picks up on the different the points that I've made from the passages from Shire I've already shown you. And then on 766 of the electronic bundle, sort of 2 lines below letter A, Lord Scarman describes such provisions, so these are allocation as opposed to entitlement provisions. Lord Scarman describes such provisions as administrative and fiscal in character, by contrast with the justiciable issue before the House. He noted, without expressing an opinion, the possibility that in that context ordinary residents might have a special meaning when the distribution of the fiscal burden between local education authorities is being considered. I won't read out the rest of the sentence. And he comments as follows: this is helpful as illustrating that the meaning of the term ordinary residence may be strongly influenced by the particular statutory context. So certainly, I said this is what Lord Scarman was doing. Certainly what Lord Carnwath is then doing is contemplating that in the context of provisions which are administrative and fiscal, ordinary residents might be given a special meaning, a meaning that is different from the, as it were, the prima facie meaning established in Shire. That's the logic of it. That in mind, there are some other bits I want to come back to, but I just come straight on to what I take to be, and I think it's probably common ground, are the key passages in the judgment. 770 of the report, sorry, 770 of the electronic bundle. Paragraphs 57 to 60. I'll just take 57 first of all, if I may. Because this is important. My learned friend says this is an important paragraph, and we agree.
Which paragraph?
57, my lord.
Yeah, thank you. Yeah.
In construing the relevant words in section 24 of the 1948 Act, so note the 1948 Act might be what's called the Receiving Act here. It's the act you're moving into from the Children Act, if that makes sense.
Yep.
So he's trying to understand what is meant by ordinary residence in that provision. The statutory context is critical. The purpose of the provision is purely administrative fiscal, allocation, not entitlement, to borrow Lord Scarman's phrase. It does not affect the rights of the person concerned, but only the allocation of responsibility as between local authorities. Lord Scarman recognised the possibility that such a context might justify a different approach as compared to one directed to a person's entitlement to a benefit. In this respect, the function of the relevant provisions in each Act, and I think he means there the Children Act and the 1948 Act, the one the court is dealing with, is the same, i.e. administrative and fiscal. And I would respectfully say, so too with the Mental Health Act. Section 117 of the Mental Health Act. So what he's saying in paragraph 57 in essence is, look, you've got to determine what ordinary residence means, not make a decision about how to extend deeming provisions, but what is the core meaning of ordinary residence in this context of of provisions which are directed to this administrative and fiscal purposes. So that's the question he sets. How does he answer it? Well, it's 58 to 60, which need to be taken as a whole. Section 24.5 poses a question in which authority's area is PH ordinary resident. And he says this: in a case where the person concerned was at the relevant time living in accommodation which he'd been placed by a local authority under the 1989 Act, it would be artificial to ignore the nature of such a placement in that parallel statutory context. He was living for the time being in a place determined not by his own settled intention, but by the responsible local authority solely for the purpose of fulfilling its statutory duties. And you'll have seen in our written case, we say, leaving aside points about gender, that can be directly transposed to the present circumstance. In other words, he goes on...
not by his own settled intention. So is your own settled intention an essential part of ordinary residence?
Well, it is part of ordinary residence under the Shah test, that's right. And there's been a controversy which I'm not sure is fully resolved by Cornwall about how you work that out in the context of a person who lacks capacity.
Well, quite.
But of course, we are in any event...
What about children?
Yes.
I mean, they live normally where their parents live, but they have no say in it.
Yes. So I have not made the argument, and I think it's recorded in the High Court, that it's critical here that JG, like P, lacks capacity.
All right.
I'm not relying on that.
Okay. No.
I mean, I think there's an argument, put it like this, there's an argument which might be made, but we've chosen not to. That's not how we...
Right. Right.
Not beyond contention, but we don't think it's right. We haven't put it.
The paragraph 59 bears to tell us the same thing in other words, and the other words are rather to a different effect.
Yes.
And the critical thing there is that we're told that under the provisions of the 1989 Act, the placement didn't affect ordinary residents.
Yes. So this is why I'm going to have to come on and deal with, and I want to deal with it if it's acceptable, as a sort of subtopic.
If I was said that placement in Swindon doesn't affect JG's ordinary residents, you're
right.
Right.
It doesn't affect ordinary residents. That's right. What it does is, but what it doesn't do, critically, until the redetention, is affect responsibility. And so the key controversy on Cornwall is this: when Lord Carnworth refers interchangeably to not changing ordinary residence and not changing responsibility. So the question is that because, as I think my learned friend would say, well, actually, it's because it doesn't change ordinary residence, it's the deeming provisions they tell you to treat? Or is it because it doesn't affect the more basic question of responsibility? And the reason he refers to them interchangeably, we do submit, is that, and I'm going to come back to this, can I just give you the marker, and I'm going to come back to it directly, but I just want to finish these passages. In the statutory context of Cornwall, ordinary residence and responsibility are interchangeable, because what those statutes all do is use ordinary residence from time to time as the thing that determines responsibility, but they then qualify that by deeming provisions which require you to treat someone as ordinary resident, someone where they're not. The point I'm going to come on to is that what you have in the Mental Health Act is something that does exactly the same thing in policy terms, in outcome, by a slightly different drafting technique. So my submission is that when you read references in paragraph 59 or 55, which I shall come back to, not changing ordinary residence, what matters is that it doesn't change, is because it doesn't change ordinary residence, it doesn't change responsibility. But as I will come back to this. And that, if I may say so, that helps to resolve my Lord Reed's point that 59 doesn't otherwise sit very happily with 58 and 60. Because in 58 and 60, he doesn't talk about not changing ordinary residence. He talks about the fact you don't change responsibility. So let's go on to 60. On this analysis, it follows that PH's placement in South Gloucestershire by Wiltshire is not to be regarded as bringing about a change in the ordinary residence. Throughout the period until he reached 18, he remained continuously where he was placed by Wiltshire under an arrangement made and paid by them. For fiscal and administrative purposes, i.e. responsibility, that's what that means, as we've seen from Shaw.
Saying that, I mean, again, this is all rather curious. The classic cases on ordinary residence are fiscal cases.
Well,
and those are what Lord Scarman was basing his approach on in Shaw.
well, hold on. We've got to be careful about the word fiscal, because I think. Forgive me if I got this wrong. I hope I haven't.
Well, I think
my lord. I think, yeah, well, exactly. They're tax cases. That's a different. I haven't got the OED of fiscal in front of me, but I think fiscal. I think does cover tax, but it's a different. In tax, it's again different. So, in broad terms, as I understand it, ordinary residence gets used for three purposes. One is what we're calling fiscal and administrative here, which is allocating responsibility. Doesn't actually affect the subject one way or another. It's just a matter of who pays. Secondly, it can give an entitlement to something, as in Shah. And thirdly, it can expose you to a burden, i.e. classically a tax. So those, I mean, you can call those cases fiscal, but it's fiscal in a different sense, clearly in a different sense than it's being used by both Lord Scarman and Lord Carnworth. When he says fiscal and administrative...
Lord Scarman was dealing with a particular context where, under the scheme of Section 31 of the Act he had in front of him, the Secretary of State had a discretion to determine where a person was ordinarily resident for the purposes of allocating financial responsibility between local authorities.
Query whether he had a discretion, or as Lord Carnworth said in a part of paragraph 43, which I didn't read on to, and ultimately the same here. I mean, that word discretion is quite a difficult word sometimes, as the court will know, because sometimes...
Isn't it a word that Lord Scarman uses?
It is the word he uses, yeah. But he wasn't. They weren't analysing. Well, but he wasn't actually concerned to decide that. And the point that Lord Carnworth makes in 43. Can I just go back to it since this point has arisen? It's immediately after the bit I read. So picking it up halfway through B and C. However, it is common ground, as I understand it, that in the present context, once properly construed, the issue for the Secretary of State was one of factual judgment rather than executive discretion. Whether that's true in Shah, we're not going to get to the bottom of that, I don't think, today. But what Lord Carnworth takes from Shah is the idea that you can give you may need to give a special meaning to ordinary residence in particular statutory contexts, especially those where the purpose of the provision, the purpose of the reference, the purpose for which ordinary residence is being used is what he means by administrative and fiscal, which is to say, doesn't affect the subject one way or another. It determines the allocation of who pays between different parties.
But isn't the ratio of the case the second sentence of paragraph 59?
Well, my lord, if excuse me, I'll just turn it back up, forgive me. My lord, my submission is that it is not. It won't surprise you to know. I understand the argument that it may be. And that's because of the point that I want to come on to. Really, the real thrust of what I want to say about that is because of the point I want to come on to about what role deeming provisions and how...
I mean, it's a very strange reason. I mean, ordinary residence is scarcely a more familiar statutory phrase.
Yes.
And when Parliament uses the phrase, which has been interpreted by the highest court in the land as that phrase has been time and again, the ordinary presumption is that Parliament is using the word with the same meaning as the courts have determined it to.
I don't want to re-argue Cornwall.
I mean, the reasoning seems to be that when you've got a deeming provision that doesn't go quite far enough but creates problems because it doesn't, you can make it go a bit further.
Yeah, well, again, that's pretty much what Lord Wilson thought. But Lord Wilson was in the minority. It is a judgment of this court, and it's binding for what it decides. I know we're looking at what it decides.
It's at best, it's persuasive in this case, because we're dealing with a different
No, I follow that. I can't simply, as it were, I can't pick up the head. It's not the sort of case where I can pick up the head note of Cornwall and say, well, boom, there you go, and we wouldn't be back here if it was that sort of case. And as the court has probably picked up by now, many people have puzzled over Cornwall over the last few years. But the fact remains, it is a judgment of the Supreme Court. My learned friend in his written case makes points about how it's an unsatisfactory case, it's not the right time to overturn it, but maybe it will have to be looked at again and so forth. My respectful submission, that's actually not a very satisfactory, well, it's not a satisfactory approach at all. But first of all, it shouldn't be overturned, regardless of its merits, because that would completely undo all sorts of arrangements. There are very powerful reasons for not overturning it.
We're not being asked to overturn.
I understand that. I appreciate that. But that leads me to my second point, which is that we submit that since it's to remain, it isn't to be overturned. It's not going to be overturned today, or in this case, and it's not going to be overturned in any foreseeable case. One ought to apply it. One ought to take it seriously as a judgment and apply it to the other cases to which the reasoning.
One should extend the anomaly.
Well, if so be it, my lord. But one ought. I mean, that's not how I put it. You won't be surprised to hear. But also, frankly, if that's what it amounts to, then yes. But what I am submitting, I hope, more attractively. I mean, I'll try and put it in a more attractive way, because I'm certainly not accepting it's wrong either. I mean, I'm just not making a submission about that.
Isn't Lord Conway saying in paragraph 56 that Section 117 is a different case?
Yes, that he absolutely is. But he absolutely is, my lord. But that's because at the time, actually the amendments come in about the same time. But and I'm going to come on to this. Section 117 doesn't use ordinary residence at all. That's the Hertfordshire case, which is the last bit of my submissions. So absolutely, if Section 117 was never amended to introduce ordinary residence and stuck with this inverted commas residence, you wouldn't apply it. You wouldn't read Cornwall on. You just wouldn't. Hertfordshire's clear on that. But think, as in a way that I shall come on to in a bit more detail, things have fundamentally altered. That's the answer to that. But my lord is right. So, my lord, I mean, I won't just read out the rest of the paragraphs because you're perfectly capable of reading them. So, can I then come on to this point about deeming provisions, which is, I think, central to the ratio? Forgive me, I just catch up with myself. So, it's a feature of the legislation in Cornwall, that's the Children Act of the 1948 Act, and it's also now a feature of the Care Act, which, as you've perhaps picked up, effectively now stands in for the 1948 Act. Does the same job, adult social care. They use ordinary residence to allocate responsibility, but they do it on the basis of ordinary residence from time to time. So if you move, the relevant authority changes. And that's not least because those statutes, certainly the National Assistance and Care Act, contemplate the provision of services maybe less than residential services. So the authority may have no role in it where the person lives. So if you're living in Oxfordshire and you move to whatever it is, Wiltshire, and you're receiving domiciliary services, fine, you get them from a different authority. But because they use ordinary residence from time to time, because of time, I'm not proposing you to take you to the underlying provisions, they're all in the bundle. Because they use ordinary residence from time to time, they are all then subject to deeming provisions in the National Assistance Act, section 24.5, and the reference is EB 334. Again, I'm not going to go to it unless you want me to. In the Children Act, it's section 105.6c, EB 396. And in the Care Act, it's section 39.1a, EB 404. And all of those deeming provisions, albeit slightly different language, have the effect that once an authority is taken responsibility, they then place you out of borough, out of area. then that authority retains responsibility. And the way that works is actually encapsulated in my submission correctly by Lord Scarman in the opening words of paragraph 58, which we've looked at for other reasons. Can I just direct your attention back to it for a moment? First sentence. Section 24.5 poses the question...
Which page are we on?
I'm so sorry. So back on page 770, which is... Which may be where you are, because
yes,
I haven't actually
page
taken
770. Yeah.
Yes.
Sorry.
Section 24.5 poses...
I'm terribly sorry.
No, I'm sorry.
I thought you said Lord Scarman.
You did by slip at the time,
I'm
but we
doing
understood that to mean Lord Conway.
Sorry, right.
I'm doing a terrible job of mixing up
It was
Lord
deemed to
Scarman.
be Lord Carman. Right.
770, Lord Carnworth, I'm so sorry. It's in the Cornwall judgment, I do apologise. Paragraph 58, first sentence. Section 24.5 poses the question in which authority's area was PH ordinarily resident immediately before his placement in Somerset under the 1948 Act. So actually, although the basic concept is ordinary residence from time to time, once you start placing people, the question becomes a different question, regardless of settled intention, by the way, in which where is your... It fixes a point in time at which the authority takes responsibility. And that is, as I shall seek to show you in just a moment, effectively how Section 1173 works as well. In any event, the other key point from this is that for the purposes of Lord Carnworth in Cornwall, the question of who is responsible and the question of where are you ordinarily resident are interchangeable. That's why Lord Carnworth in Cornwall can express himself in some cases as, well, it's about who retains responsibility, and in some cases about where are you ordinarily resident. Can I show you another example of that, paragraph 55, which makes it, I submit, particularly clear. So this is 769, previous page. So it is highly undesirable that this should be so. What's undesirable is that the responsibility shifts. See paragraph 54. He goes on, it would run counter to the policy discernible in both acts that the ordinary residence of a person provided with accommodation should not be affected for the person's and authority's responsibilities by the location of that person's placement. I'm so sorry, 55, first sentence. So what he's saying there is it's about whether ordinary residence shifts, not about whether responsibility shifts. But if you read the rest, can I ask you to read the rest of the paragraph? It's clear in my submission what he's actually getting at is responsibility and not ordinary residence for its own sake. In other words, the policy of the Act that he is identifying is not that it doesn't, the ordinary residence doesn't move under the Children Act. It's that responsibility doesn't move under the Children Act. And if that's the right submission, if that's correct, for example, about paragraph 55, I say it's also correct about 59. So it's the sentence that my Lord Legate fixed upon, the second sentence, I think it is, of the last sentence of paragraph 59, it says, since one of the characteristics of that placement is that it did not affect his ordinary residence under the statutory scheme, so that seems to be talking about ordinary residence, it will create an unnecessary, etc. mismatch. So it's an incidence of the case that he can talk about ordinary residence there, because ordinary residence and responsibility are interchangeable under this Act. But it's clear if you read the passages as a whole, and if you read 55, for example, what actually matters is the policy of the Act to preserve responsibility, not the policy of the Act to preserve ordinary residence for its own sake. Because ordinary residence only matters because it goes to the question of responsibility. So if that's the right way to understand Cornwall, then one comes back to the to the Mental Health Act, section 1173. And now we need to look at the relevant provision, so it's 358 of the electronic bundle.
And do you maintain that there is what Lord Carnworth described as a policy discernible in the legislation that the ordinary residence shouldn't be affected by the person's location.
So what I say, and the submission I'm coming to directly now in relation to the Mental Health Act, is that there's a policy discernible in the legislation that responsibility for the provision of the service shouldn't be affected by the out-of-borough placement. That's the submission. And to make that good, if we go to 358, please. Subsection 3 is the relevant one that deals with ordinary residents, and we only need A. So we've looked at it once before, but in this section, the CCG and the Social Services Authority, etc., means ... the authority A, because we're in England, if immediately before being detained, the person concerned was ordinarily resident in England for the area in which he was ordinarily resident. So that does exactly, it's not a deeming provision, it doesn't tell you to treat him as ordinarily resident in one place or another, but in substance it does exactly what a deeming provision would do. It fixes responsibility by reference to ordinary residence at a particular point in time, in this case prior to detention. And for that reason, because it uses that technique, actually the use of a deeming provision here would be otiose or incomprehensible. Because once you've got that provision, you've fixed responsibility by reference to ordinary residence at the point in time, at least for so long as you don't have a second detention, that's the hiatus. Responsibility doesn't move if you then have an out-of-borough placement. It is, in my respectful submission, exactly the same policy, albeit achieved by a different drafting technique, which Lord Culmouth identified in the other statutes. And so the submission is that the ratio, it would be artificial. It's artificial to confine the ratio of Cornwall to a case where you've got a deeming provision or where ordinary residence itself is fixed, in circumstances where ordinary residence only matters because it determines responsibility, and you can have, as we see in section 117, a parallel situation where no deeming provision but exactly the same policy outcome is achieved.
So the question is, why isn't there a deeming provision?
Well, the answer presumably, but this is a problem really for Cornwall. So, my Lord, that's a question which can be asked of the Cornwall situation.
Well, it can, but there is a deeming provision in Cornwall, but it expired. Isn't that right? When the the individual turned 18.
It only was only within the legislation.
Yeah. So each deeming provision, all of the deeming provisions are confined to their own legislation. That's the way it works. Mm. And so, if you can't, in my submission, you can't.
Is this right? There was a deeming provision in Cornwall. There was a deeming provision which applied.
There was a deeming
to the individual until he was 18.
Yes, correct.
Yeah.
Correct. And then at the critical,
there isn't a deeming provision applicable at any stage.
No, but there's something directly analogous. So in Cornwall, you've got a deeming provision which applies for so long as until he's 18.
Yeah.
That deeming provision absolutely clearly does not apply when he turns 18.
Yeah.
And what the Supreme Court does, so if you just apply the language of the statute, you don't get, you're back in Wiltshire. You're in South Gloucester because that's where you're actually living.
But it's the deeming provision that sets the scene, doesn't it, for what Lord Culmouth then says is the right answer.
Well,
I mean, if the deeming provision weren't there, are you saying that the Supreme Court would come to the same answer?
So, my Lord, it is and it isn't. And I'm sorry, but let me explain that. I don't want to leave that hanging. It is the deeming provision which does that, but the critical issue is why does the deeming provision have that effect? Is it because, as I think my learned friend would want you to hold, is it because because the deeming provision tells you to treat someone as ordinarily resident in one place or another, or is it because the effect of the deeming provision is to tell you who's responsible? by the outcome of the deeming provision. The deeming provision only matters because it tells you something about who has responsibility.
No, it tells you where they're resident, and from that you decide who's responsible.
It creates a statutory fiction
Yes, it does.
as to where the person is ordinarily resident.
And that then tells you who's responsible.
Yes, but the only reason that matters under the statute is because it tells you who's responsible. So Parliament's purpose wasn't to preserve ordinary residence for the sake of preserving ordinary residence. Parliament's purpose was to preserve ordinary residence for the sake of preserving responsibility. The policy outcome that matters is the preservation of responsibility, not the preservation of ordinary residence for its own sake. That's what I submit. Must be right. Otherwise, ordinary residence just doesn't matter for any other purpose. Doesn't matter for any other purpose under any of these statutes.
So you say the fact that different drafting technique has been used shouldn't make a difference to the outcome?
That's a submission, yeah. Because the same policy of preserving responsibility is inherent. Now, obviously, I then have to acknowledge, well, yeah, but it doesn't do it in the case of the second detention, and that's right. But that's effectively the analogous problem which you have in Cornwall. The deeming provision doesn't do it when you move legislation. And the Supreme Court answers that, again, in my submission, in my reading of Cornwall I invite you to adopt, by saying it doesn't matter because there's an underlying concept of ordinary residence, which, let's acknowledge it, does actually make the deeming provisions in Cornwall odious. And you know, for the avoidance of doubt or not necessary or whatever. But the Supreme Court accepted, and Lord Wilson thought that was problematic, and maybe a different court would also think it was problematic, but that's what they decided. Mm-hmm. Yeah. And so they, I mean, it's expressed in the judgment. Sorry, I'll go back to the judgment.
Effectively, the Supreme Court decided that the fiction should be continued beyond the age of 18 for policy reasons. And Lord Wilson, I might think understandably, took the view that that was a matter for legislation rather than judicial.
Well, sure. And Lord Wilson took that view. One has to be careful about saying they did it for policy reasons. I mean, the majority would not have said they did it for policy reasons. They would have said they did it for reasons to do with which is distinct, the policy they discerned in the statute, Parliament's purpose. I know that Lord Burroughs uses. Now, Lord Wilson didn't believe that, but in a sense that doesn't matter because he was in the minority. So what they're saying is you can discern the parliamentary purpose policy in the statute. It's sufficiently clear-cut that we should interpret this concept of ordinary residence, which is a protean concept, it's open to different meanings in different contexts, as covering this situation. And if one accepts that step in relation to the National Assistance Act, and etc., then in my submission there's no reason not to accept it in the present context. Unless the deeming provisions by themselves are critical, but the point I'm going to, danger of repeating myself, so it's artificial to say it's just about ordinary residence per se, as opposed to the reason ordinary residence matters, which is the preservation of responsibility. That's the submission. I suspect I can't improve on it, so when I come to the final bit of this part of the argument. My Lord, the last bit then is to deal with the issue raised by my Lord Hamblin, which is, well, what about, after all, what about paragraph 56 of Cornwall, and what about the fact that they said it was different under the Mental Health Act? The short answer to that, but then we can go to the Hertfordshire case in a moment, is that, as you may or may not have picked up, the Mental Health Act is amended by the Care Act, all comes into force just after Cornwall's decided, so as to replace the pre-existing concept of residence with the concept of ordinary residence. And that's why and so what's been said by my learned friend and what's been said by the Court of Appeal is, well, especially if you look at the Hertfordshire judgment, which is referred to in paragraph 56, that in any event defeats this argument. So we need to look at Hertfordshire. Forgive me, I'll just find my reference to Hertfordshire, which I have at Authorities 39, starting at page 64, EB 644. So Hertfordshire is I think it is important to say it's a very odd case, just in terms of the way it gets to the Court of Appeal. You can see that, first of all, just from the head note itself, 644, because the head note doesn't include the usual recitation of the facts, and we'll see the reason for that in a moment. So the head note simply tells you the ratio. The term is resident, as the court will have it. The term is resident in section 1173 of the Mental Health Act does not have the same meaning as is ordinarily resident in section 24 of the National Assistance Act. That's the ruling, and that's the court's only ruling. Now, why is the court confined in that way? Well, it's summarised, it's really explained in paragraphs 2 and 3 of the judgment, page 646 of the bundle. I won't ask you to read it out now for reasons of time, but I'll just summarise the effect of it. There are two claims for judicial review. The first involves Hertfordshire as claimant, Hammersmith as defendant, and a service user called MW. The second involves Sutton as claimant, Hammersmith again as defendant, and a service user called JM. But in the first case, the substantive judicial review is resolved by agreement, and Hertfordshire press on the point of principle alone. It's an academic argument. And in the second case, it's not agreed, and Mr. Justice Mitting rules upon it. But then there's an appeal to the Court of Appeal, and the appellant is Hertfordshire, remember, whose case has been resolved as an academic case. The defendant is therefore Hammersmith, and the interested party is JM, who's not party to Hertfordshire's case. So it's all pretty, frankly, messy, one might say, and one might have expected the court not to rule on it at all. That's the context in which JM's facts are set out. We needn't look at them, I think, paragraph 6 to 12. But if we then go on, please, to 655 of the judgment. Sorry, 655 of the electronic bundle, I do apologise. Paragraph 35 of the judgment. Lord Justice Carnwath, as he then is, says as follows. It is important also to remind ourselves that the facts of JM's case, though useful by way of illustration, are not formally an issue before us. The issue is one of principle. The only substantive relief sought by Hertfordshire as appellants is a declaration which is formulated in the notice of appeal as follows, and he sets it out. What it amounts to is, again, you might think a pretty surprising declaration for the court to be entertaining at all, but it amounts to a declaration that is resident means the same as, has the same meaning and for all purposes as is ordinarily resident. So that's the context in which the Court of Appeal then rules, and you see the critical bit of the ruling, 657. 44, he says, sympathy for Hertfordshire's arguments, but then the critical bit is really 45. Can I ask the court to read 45? So, in my respectful submission, not surprisingly, the Court of Appeal is wholly unwilling to entertain the direct declaration we've seen. There may be many reasons for it. The very simple reason is, well, you've got a different choice of language by Parliament, is resident, is ordinarily resident. Quite wrong for the court to make a general declaration that they have the same meaning for all purposes. I accept that's plainly the right thing to have done and plainly correct. They may sometimes mean the same thing in practice, who knows, but they don't have the same general legal meaning. But the Court of Appeal and my learned friend, and I think the Mr. Justice Linden as well, all effectively said, well, Hertfordshire precludes applying Cornwall in the context of the Mental Health Act. But that can't be right. It would be right if the Mental Health Act was not then amended, but it can't be right when the Mental Health Act has been expressly amended to do exactly that which Lord Justice Carnwath, as he then was, contemplates in paragraph 45.
Well, not exactly, I think, wasn't there, because there wouldn't be the deeming provision that there was in 1948.
You're right. So I've already acknowledged that section 117 works in some respects differently. But the point made in paragraph 45 is that Parliament has chosen to use a different root concept, residence rather than ordinary residence. Whereas now, Parliament has chosen to use deliberately chosen, by amending the 1983 Act, to use the same root concept. And not only that, but they tell us why they did it, and that's in the explanatory notes, which are admissible as an aid to interpretation. I think that's accepted, I'm not sure if it is. I'll go to the paragraph.
They're of almost no use. They're written by civil servants after the event, and you know, the idea that this court should be looking for that kind of assistance strikes me as ridiculous. They are occasionally, they're admissible as a way of identifying the mischief.
Well, can I show you what they say, and then we can come back to what you take from them, because they're very short. It's page 1075 of the electronic bundle. Sorry, 1074 to 1075 of the electronic bundle. This is dealing with section 75 of the Care Act, which is the amending provision.
Because these are not before Parliament, you know.
No, they're not. But, well, I mean, there are other indications to the same effect. Let me just show you 448, because what it says is, in my respectful submission, obvious anyway from the sheer fact of the amendment. Subsections 3 and 4 of 75 apply the ordinary residence rules to section 117 in order to avoid anomalies which can currently arise when one local authority is responsible for commissioning section 117 services, whilst another commissions any other services a person may need. They apply consistent aftercare ordinary residence rules, etc. So the express purpose of introducing the concept of ordinary residence into the Mental Health Act...
No. Your language is ignoring the difference between a civil servant in a department's view of what purpose they were trying to achieve by the legislation and Parliament's purpose, which we have to derive from construing the language that it used.
Well, the language that it used...
In its context.
Well, my Lord, I do say that you can get it from the language of the statute, because all that section 75 does is replace the pre-existing rules with the new rule, with the rule that we've been looking at, which expressly and deliberately uses the concept of ordinary residence. And Parliament was plainly alive to the fact that that's the concept used in all of these other statutes. So one can, in my submission, what you see in the explanatory notes is only telling you something which is obvious in any event, which is that what Parliament was intending to do, subject obviously to the difference in how, when you look at ordinary residence, is to introduce the same root concept, ordinary residence, as interpreted by the courts, into the Mental Health Act as well as to the... So my submission is simply that in those circumstances, it's obviously right that if you looked at this case in 2010, if Cornwall had been decided in 2004 and you looked at this case in 2010, before the amendments, you wouldn't try and read across from Cornwall to the Mental Health Act. It would be impossible. But in my respectful submission, if I'm otherwise right about the ratio, and okay, that's the matter you have to think about, but if I'm otherwise right about the ratio and the role that the deeming provisions are playing, the Hertfordshire judgment in particular, which the Court of Appeal, I haven't taken you to it, but made an awful lot of, and my learned friend makes an awful lot of, doesn't stand in the way. Quite the contrary. The exact circumstances which led the Court of Appeal in Hertfordshire to reject a link between the Mental Health Act and the National Assistance Act have now been removed by provisions which deliberately use the same language, or which use the same language.
The deeming...
Well, fine. But that's the
analogy being drawn from the 1948 Act was rejected by Lord Justice Carnwath for two reasons that he gives. One is a different phrase is used in the legislation, and secondly, there is no deeming provision. And they've now amended it to have the same phrase appearing, ordinarily resident or whatever it is, but there is no deeming provision.
Well, again, but that's subject to his thinking in the Cornwall judgment about... I mean, obviously all of this depends upon the submissions I've made about Cornwall. If I'm wrong about Cornwall, the Hertfordshire point doesn't matter.
Your point is that one of the arguments used against you has been knocked out by this change in the wording.
Exactly, and I say that in itself doesn't do the job. So we're back to what does Cornwall mean, and is it, if I can characterise it in this way, is it about deeming provisions, or is it about the reason for which the deeming provisions exist? That's the submission, which, as I've said, on that part of the case, I suspect I can't improve on, so for better or worse.
Are you going to say anything about the effect of Section 39 of the 2014 Act and what the Court of Appeal said in paragraphs 80 and 81?
I confess that I wasn't planning to. Let me just see if it's...
But that's what that is partly addressing, I think, the point you've just been addressing to us. So it's aligning ordinary residents under Section 117 with residents for the purposes of care and support under the Care Act, as I understand it.
Forgive me, my lord. Did you say paragraph 88 and 89?
Of the Court of Appeal.
Of the Court of Appeal. Can I just reread them, because it wasn't a point I'd intended to say anything about. But
I mean, the point they're making is, if you're right,
no.
It was unnecessary to introduce Section 39(4) in the 2014 Act.
Yes, that's right. I mean, that's...
You accept that?
Well, it's the same...
It's just a sort of a mistake made by the...
Frankly, it's unnecessary anyway. It's unnecessary even if I'm wrong. Just as it's... So if one goes back to Cornwall itself...
Well, I mean, I just want to... Just on the words of the statute.
Yes.
I mean, if you're right about Cornwall, I mean, why was this necessary? Well, that's the whole point. Why was Section 39?
Well, they're there for the avoidance of doubt, is the short answer.
I see.
But I just want to... this is quite important, because we made this point at some length in the written case. That problem is equally true whatever you think the ratio of Cornwall is. So if you think about Cornwall itself, its Pre-Care Act, there's no doubt, even if the ratio of Cornwall is confined to cases involving deeming provisions, and you extend the deeming provisions, the effect of the judgment in Cornwall is to render those deeming... I mean, they're relevant because they help to discern the purpose.
I'd like you just to address Section 39, which you'll see set out in the Court of Appeals judgment at page 223 in our bundle, paragraph 25. Because, I mean, in short, the point is that subsection 1 introduces a deeming provision.
Yes.
But not for people receiving care under Section 117.
Yes.
For Section 117, that deeming provision doesn't apply for the provision of care and support. Instead, it's their ordinary residence under 117 which applies. That's, I think, the effect of it.
Sorry, forgive me.
Well, if you have to look at... all right.
Section, which is the subsection?
Well, you need to look at
yes.
Subsection 1.
Yes. I'm sorry.
And then subsection 4.
Yes.
So 1 is the deeming provision, but 4 is a carve-out from the deeming provision.
I'm not sure if...
Isn't that right?
Not sure if it's a carve-out, but just because I might be wrong about that. My Lord, I'm a bit nervous about...
Well, anyway, we have what the Court of Appeal said. I just wanted to know whether you wanted to say anything about it.
My Lord, for present purposes, I mean, I think if the Court were willing to allow me to make a short written submission, I'm not going to try and do it now because I don't know. I frankly don't know the answer, and it would be silly for me. It would be a mistake to try and pretend I do.
I think you probably submitted to the Court of Appeal that it was there out of an abundance of caution.
Yes, I mean that is the general submission which I was going to make, and which I absolutely have to make. But again, I do say this is a problem for my learned friend too. Is that however you think about Cornwall, it does render some of the more specific deeming provisions redundant, OTOs, whatever it is. There's just no way around that. That's Lord Wilson's point, amongst others, about why he thought they were wrong. So far as it goes, I mean, I quite understand why that's thought, if I were arguing Cornwall, that might be thought to be, and trying to contend for the outcome in Cornwall, that might be thought to be a problem. But that's water, in a sense, it's water under the bridge. But the other point that I can, I think, make, and again, we made this point in our written case, is that unlike Cornwall, the extension of the Cornwall logic to the particular scenario we're dealing with doesn't render any particular deeming provisions OTOs. I don't think it renders the section 39.4 deeming provision OTOs. That's OTOs anyway. But I want to be a bit cautious about that. But
I think the section, because it's right, the 2014
because,
Act.
can I just have a...
Dated Cornwall. Dated.
Yes.
Yeah.
Well, yes, and you've got to remember what it really did is it restated, for most purposes, it restated the equivalent deeming provisions in the earlier legislation.
But I think this was new, wasn't it?
This is new, but can I just have one moment on this, because I just want to remind myself of one point. Yes, you need to be a bit careful about what you might call the direction of section 39.4. So section 39.4 is dealing with the scenario where the person moves from section 117 to
well, with respect to, I think it's dealing with a person who is receiving aftercare under 117
yes, that's what I'm
by
saying.
local authority A.
Yes, correct.
And they don't want local authority B to be providing care and support under the 2014 Act.
Yes, so
they want to have the same local authority providing it.
So it's another.
So they disapply the deeming provision in subsection 1. Mm-hmm. So arguably to restore not a deemed position but an actual position.
As I say, I think trying to deal with it on my feet is
All right. Well, you may have dealt with it in your case, I don't know. Your written case.
I don't think we did, but
Okay.
I'm just gonna,
Well, there we are.
kind of used to suggest it, but I don't think we did. In fairness to me, I don't think it's a point that's been put against me, but
I see. Well, the Court of Appeal did, so.
no, well, fair enough. Maybe we should have done. We are. My lords, those are my submissions, unless, of course, there are any questions.
If you want to deal with the section 39 point, I'm anxious to avoid what sometimes happens in these situations where we end up with a prolonged exchange.
Yes, I understand.
Blast and counterblast.
Yes.
Would you be in a position to put in some brief submissions about this within, say, 7 days?
Yes. Yes.
And it would allow Mr. Sharman a similar period,
yes.
And that would be that.
Yes, and I fully understand that it's limited to that point. We're not going to go beyond it.
Yeah. Okay.
I'm grateful for that, my lord. So those are the submissions then.
Thank you very much, Mr. Bewley. Mr. Sharman.
Good afternoon, my lord. What I plan to do is reply on the appeal and then move on to my response on the cross appeal. I'm going to begin with ground 2 of our appeal because logically or temporarily that comes first. My lord, the language of section 117 subsection 6 is absolutely critical here. And to an extent, I'm reiterating points made by the court, albeit hopefully adding something. Firstly, what are aftercare services? My learned friend suggested aftercare services includes planning and so forth. My lord, that is, we say, incorrect. And there is a separate statutory provision in relation to assessment and planning in the Section 117 context, which unfortunately is not in the bundle before you. But if I can give you a note, Section 47 of the National Health Service and Community Care Act 1990, that's Section 47 of the National Health Service and Community Care Act 1990, provides for the assessment and the planning bit. The aftercare services, the provision of services, is what is being dealt with in Section 117. It is not prior planning. And when one looks at the definition of aftercare services, it is clearly impossible for aftercare services to be provided once someone is detained pursuant to Section 3. Because at that point, you cannot be within section 1176B because it's provision of services to reduce the risk of someone requiring admission to a hospital again for treatment for mental disorder. It doesn't say for treatment or assessment. So it's clearly a reference to section 3 and some of the other provisions. So as a matter of language, it is simply impossible to provide aftercare services at that point. But the same argument does not apply to detention pursuant to section 2. And in reality, people who've been detained pursuant to section 2 for assessment may be a category of people that are particularly in need of aftercare service to stop this developing, so they need longer detention, my lord. Now, next point I want to respond to is my learned friend's point about the language of 1171 and there being 3 criteria. And as I understand his argument, he says as soon as someone is in hospital, they don't meet the 3rd criteria in his analysis, and therefore it proves too much. And that was an argument that both courts below took. And that's where our composite criteria point comes in. It ceased to be detained and then leaves hospital. It's not leaving hospital generally, it's leaving hospital after you have been detained pursuant to section 3. And if the court analyses it in that way, the composite criterion, it doesn't prove too much. That's why we say it's essentially... We quite accept the individual has to leave hospital before aftercare services can be provided. There's no dispute there. But what we're saying is it's a composite criterion because otherwise detention, voluntary detention or detention pursuant to section 2 would bring an end to the aftercare services. That's where the prove too much. So that's our answer to the prove too much point. And that's why we say there's 2 criteria. It should be interpreted in that way as a composite criterion. That's all I wanted to say on ground 2. Ground 1, as I understood my learned friend, at the point where the second detention has ceased and JG leaves hospital, it is accepted on the Secretary of State's case that all the criteria under subsection 1 are still met. It's accepted that there must be a duty on a local authority. And as I understood it, given the concession in relation to Proposition 2, that local authority must be Swindon because it is the local authority where he was ordinary resident immediately prior to the second detention. So I'm not entirely clear how the Secretary of State's argument works here. It essentially is, well, you just ignore the language of the statute where you have a second detention.
No, it isn't. It's that you've already got that obligation that's arisen by reason of the first detention, and it hasn't gone away just because you've added in another obligation that arises by reason of the second.
Well, then you have 2 competing duties, and Section 1173 tells you the critical duty, we say, and it's accepted that 1173, because 1173 tells you which authority has the duty to do it, and it's accepted that Section 1173 means immediately before the second detention. See what is said in relation to Proposition 2. My Lord, one point that I don't think came out this morning, an individual who's detained multiple times pursuant to Section 3 is not necessarily detained for the same reason pursuant to Section 3. So in 1990, they could have been detained as a result of severe depression, but in 1995, it could have been psychosis or schizophrenia or something. And that we say, so when one's considering aftercare, it's the reason for the second detention that is particularly important. So the aftercare that related to the depression is perhaps more peripheral if someone has been detained for treatment 5 years later as a result of schizophrenia. So we say that's a very minor point that would support our argument that where there's competing duties, it should be on the second authority, or Swindon in this case. My learned friend's argument on our first ground is that absent death, Section 1172 sets out the exclusive route to bring the duty to an end. But as the President, Lord Reid, noted, that can't be right. Look at deportation, extradition, moving to Australia, for example. And my learned friend said he'd come back to that and very sensibly didn't, because he doesn't have an answer, my lord. And that...
Well, I suppose it might be said that the Act doesn't have extraterritorial effect.
Well, that doesn't meet the imprisonment suggestion or the death suggestion, my lord.
Right.
Well, death, he says, there's no person. The others, he can say, well, the duty may in theory continue, but in practice it has no content because there's nothing you need to do. And if you want to formally terminate it, you can sign it off under the statutory process.
Well, it may actually be very difficult to sign it off, because you can only sign it off if you reach a joint decision that the person is no longer in need of such services. But if someone with acute mental health problems is deported to Somalia or whatever...
I come back to my extraterritorial effect. How can the local authority provide support in Somalia?
No, well, maybe this point doesn't take me very far.
No, I mean, it was my point, but I don't think it's the most compelling objection to the arguments.
My lord, that's all I wanted to say on my appeal, unless there were any questions that have occurred to your lordships in relation to that. Turning now to my learned friend's cross appeal as to the meaning of the phrase ordinary resident in section 1173. We say that the respondent's submission is, in essence, as a result of the Supreme Court's judgment in Cornwall on fundamentally different statutory provisions, this court should read in a deeming provision that is not there, whereby residents following placements made pursuant to section 117 is disregarded for the purposes of ascertaining JG's ordinary residence. What, in effect, the respondent is asking this court to do is legislate, and legislate to a far greater extent than the court in Cornwall arguably legislated. The critical point in Cornwall, and I would agree with what Lord Leggett said as to the ratio of Cornwall, it's the second sentence in paragraph 59, where you have two parallel deeming provisions, the court essentially joined them up. It extended the second deeming provision in the National Assistance Act to apply to placements under the Children Act as well as under the National Assistance Act. It was a small extension of the deeming provision in those terms. I think there's a lot of force in Lord Wilson's criticism of that. It doesn't accord with the clear language of the statute. But if I could put it one way, what the court in Cornwall did was take a couple of little pixie steps beyond the language, and what my learned friend is asking you here is to take huge Goliath-like leaps in relation to statutory interpretation. He is trying to write in deeming provisions which simply aren't there in Section 117. Section 117 has been amended repeatedly. If you look at the text of Section 117 on page 359, you have a list of the various amendments that have been made to this Act, and on none of those occasions have deeming provisions been inserted. It's not relevant to statutory construction issues, but it might be of interest. But the draft mental health bill, which hasn't got before Parliament, does look to include deeming provisions in section 117. But that is only a bill, it's a very early stage. But Parliament has repeatedly decided not to include deeming provisions here, and this court should not basically say, well, that's very interesting, but we're going to imply a deeming provision here, my lord. That is not the role of this court. My lord, the President, Lord Reid, said Cornwall is persuasive at best, and I would emphasise the at best. As I had understood my learned friend's argument until he agreed with that comment, I had understood him saying that Cornwall was binding on this court. If you extracted the ratio, it would determine this case. But we say that is clearly not the case. It is completely different statutory language, and two statutory schemes, the Children Act and the National Assistance Act, both of which have clear deeming provisions in them. Now, as you're aware, my lord, this argument was rejected by both the High Court and the Court of Appeal. If you look at the judgments, there's far more ink spent on this than the actual appeal. We have limited time. Can I just, for your note, say our written case on the cross appeal is set out at paragraphs 100 to 137 of our written case. That's page 145 to 158. The Court of Appeal addresses at paragraphs 59 to 99. That's page 233 to 240. And the High Court at paragraphs 31 to 133, which is pages 250 and 275 of the bundle. We say our submissions essentially adopt the earlier consideration. But the key point is the ratio of the Cornwall judgment is, well, we say the second paragraph of paragraph 50, the second sentence of paragraph 59. The existence of the deeming provisions were absolutely critical to the reasoning. I think that is very clear from the paragraphs, and we don't have such similar provisions. In our case, we say Cornwall has rightly been described as a controversial case. We say we don't need to say it's wrong, and that appears to be common ground. But given the problems with it, we say it simply isn't persuasive, and without Cornwall, there is nothing to the Secretary of State's argument here. It's quite clear that Cornwall is absolutely critical. So, my lord, those are my very broad brush submissions. If you would like, I can go into a bit more detail. I'm really in your hands. Would you like to hear me in more detail on the Cornwall argument? It's all in my written case.
No, I think you've dealt with it adequately in your case. Thank you, Mr. Chairman.
Very grateful then, my lord. Thank you very much.
I have just one question, if I may.
Yes, of course.
I've just got section 47
Yes.
of the National Health Service and Community Care Act 1990 up here.
Yes, my lord.
Could you just tell me whether it applies while a local authority is providing aftercare under section 117, or whether it applies only prior to providing aftercare?
I think it applies. One is going to need to assess needs prior to the provision, but one may need to assess needs again a year later if needs have changed. So I think it's both prior to and after.
That's right. Okay, that's what you'd say.
Very grateful, my lord.
Thank you very much. Well, it's really quite a short point of statutory construction on one view, but it's been very fully argued, and we're very grateful to all counsel and those behind them for the depth of the argument that we've received. We'll let you have our decision as soon as we can.